So the topic of discussion today is going to be religious family mediation. So I'm sure over the past, few months you've seen occasional headlines pop up about, Sharia courts, and so I think what we're going to do is dive into a little bit more about what powers these Sharia courts or other kinds of religious mediation has, and some of the advantages, disadvantages. A lot of what you might have seen in the press is how potentially some religious courts can disadvantage women perhaps in some situations. So we're lucky to have with us two lawyers on our panel today. So we have on my right we've got Jazvir, and on my left we've got Shabana. So they're both barristers, and I'll let them introduce themselves. So I don't know who's going to speak first. If you have one,
yeah,
you want to go first? So Shabana's going to go first. So hand over to you.
Great. Thank you for turning up. I know this is a bit of an unusual topic. We were going to speak specifically about the Baroness Cox bill, which has been in the press a lot, but we thought we'd give a lot of our audience some general information. Before I start, so I'm Shabana Salim. I'm a barrister at Charles Russell Speechlys. I practice in international family law. We work predominantly with families that might have a Muslim background from the Middle East, or what we have a lot of now, which is mixed marriages, so Muslims, non-Muslims, or not British nationals and non-British nationals. This comes up quite a lot because even in international marriages, parties might prefer to mediate because it's a lot less costly than going to court, particularly in England. So what we want to do, what I will do before I start delving into the issues is just define what we mean by religious family mediation today. We're going to focus on Muslim mediation and also Sikh mediation because you have two panellists who have experience in those two respective fields. But this is part one of two seminars. The second seminar will also consider Jewish mediation, which is obviously the most well-established of, I believe, all the ethnic minorities that practice religious family mediation. What we mean by mediation, we're going to typically refer to two people because that's generally the kind of work that we do, but it does also involve people that might be 4 or 5 people, groups of people. We tend to have community mediation and also business mediation. The issues, obviously, family. What do we mean by family? Well, that can be incredibly broad, especially within the ethnic minority community. So while family should mean divorce, marriage, children, finances, financial settlement upon separation, it can also lead to property disputes because, as members of this community might be aware, often parents put properties in their children's names that don't typically belong to the children, they're held on trust, or they might have family businesses that overlap a lot with the marital relationships. So mediation can then begin to encompass property disputes and family disputes. And then also what we mean by, we're going to explore a lot, I think, tonight about what we mean by mediators. Who are mediators? What are their roles? What should their roles be? Are religious mediators really fulfilling that role? How are they, what is common practice in England? The mediator role should be one where you have an individual who is trained, who is experienced in mediation, who is an impartial, independent third party that doesn't have a bias to either one of those that requires mediation, and the one that is most commonly misconstrued, that they are a facilitator. So they're not to assume the role of a judge, they're not to assume the role of one who is to determine the issues or pass judgment on the issues. They are simply there to facilitate communication between two people that are having difficulties, to try and help those two people come to an agreement and a consensus. It might be about what the issues are, and that might be all they agree on, and that helps them in court because then they save time. Or it might be all the way to the end in terms of what the agreement should be to resolve those issues. That's what I find in my experience is really what we have a lot of difficulties within the Muslim community on. And what we won't really explore that much in this first part of the seminar is intermediaries and lawyers, just so that you're aware, you can have representatives who attend mediation with either one of the parties, either the husband or the wife. Typically that doesn't tend to happen with the ethnic minority community, so we won't explore what their role is. So that's what we mean tonight by religious family mediation. What I'm going to do is explore what I'm just going to set out what the civil law system is, just so you know what role mediation has in determining family disputes in England, because that really is the benchmark. And you need to understand that benchmark so you can understand the context of how religious family mediation is perceived and why it's perceived that way. So secular family mediation. The civil courts changed the laws not too long ago, and they require now that two warring spouses have to attend a mediation information assessment meeting. It's called MIAMS, and that is compulsory. What it means, the reason for that is because simply the courts are overstretched and overburdened with a lot of family law issues, particularly given that people don't have legal aid and they're going to represent themselves, so they tend to take double the time determining these issues. By requiring them to attend a MIAM first, they sit down with somebody who's trained in the field, they get an impartial assessment about what needs to get done, and then they're invited to mediation. What we're finding is because people don't have lawyers, they won't take that advice that seriously, but the government's doing things to help with that. It's still voluntary though, so while attendance to that first meeting is compulsory, the mediation itself is voluntary in England. In other parts of Europe it's not. In some countries it's compulsory to actually try mediation. Now there are exceptions to that, and it's really important you understand these exceptions, the most important one being that you do not attend the MIAMS and you shouldn't need to do mediation if there is allegation of domestic violence. If there is any threat of violence or harassment, then naturally parties are not required to mediate. So that's the sort of basis on which it's done, and the process itself has been established since, I think it started taking off around World War I. So it's been long established the process should be an initial meeting, and then you have a more in-depth meeting where there's an opening statement. Either side gets to have their own 5 minutes say without being interrupted. Then an exchange. Sometimes this exchange can't happen with the people in the same room, which I find happens more often than not. So you have each spouse in different rooms, and you have a mediator shuffling between. And then you have closing statements. And then you have a third meeting, which is the closing, and that's when you sort of have people, having gone away and reflected on what happened in the second meeting, come together, they decide to try and formulate some kind of an agreement and finalise that. 3-step process, typically, face-to-face. It can be more, it can be less, it depends on what people agree on. And the mediator itself is typically accredited. That means there's an established organisation in England which provides regular training that the mediators have to subscribe to for them to remain accredited. And also there's a lot of client feedback and client reviews, which is well established within the civil system, which the reason I'm highlighting all that is because these are the key things that I think are missing in the ethnic minority system. So now starting with the Islamic family mediation. So as many might be aware, there are as many different types of Islamic schools of thought as there are probably different types of people in the world. I mean, it's just so varied, and it would be impossible for me to sit here and tell you that there is a set process for family mediation. There isn't, and the main reason for that is because it is so informal. It really is flexible to the highest degree, and that's why it is used so often by the community members. It can be, anybody from a community elder to somebody at the mosque to somebody at the school. I've seen teachers try and mediate between spouses. And so for that reason, there isn't really much understanding about what a common process is for Islamic family mediation. But what studies have shown, and what my experience has shown, is that the disputes that come up, there is some commonality between the disputes that come up for religious family mediation. So you tend to have a lot of issues arising around the talaq. Can the woman be granted a divorce? What's restricting her from being granted a divorce? She needs to refer to mediation to try and help her with that. I'm going to bring that into family mediation, although some people might try and say that's religious arbitration, because under English law you cannot have religious arbitration, you cannot have Sharia arbitration on family disputes. So to me, that is an example of family mediation. Again, you would have disagreements about who gets to stay in the family home. A lot of disagreements naturally about who the children should live with, how much contact they should have with the non-resident parent, how much maintenance the child should get, if any maintenance should be given to the spouse who has the children and can't work full-time, and then what's financial settlement, if there are adequate assets. So there's a lot that tends to feed through in the issues that can be addressed. But the main issues we're having are about the perception of whether British Muslim women are voluntarily subscribing to religious family mediation, or whether they're being coerced or sort of pressured into it. And a lot of misinformation about why they're using religious family mediation, perhaps in the context of Sharia councils. So, I mean, a lot of those are probably exploring Q&As if those are issues that the audience wants to consider in more detail. But essentially, a lot of women, British Muslim women, have used Sharia councils to try and secure the locks, and that's what's really driven up the surge in the usage of religious family mediation in the context of Sharia courts. The problem has been that the representation of female Muslim scholars within these Sharia councils has not developed at the same pace, and that's what's caused the problems. But what is agreed, so a lot of evidential issues, a lot of process issues feed through because of that. How much can a woman engage, and how much opportunity can she have to have her say in a process which is perhaps predominantly male-driven? That varies wildly across England because the levels, the quality of service in family mediation in Sharia councils varies so much. You have well-established councils, one of whom Kola Hassan is a member of, and she'll be attending the second part of the seminar to explain what her role is. But then you have a lot that are just sort of, people, elders within the community who might be even your uncle, grandfather, who decide that they want to sort of weigh in, and obviously they have a natural bias. So there's a lot here that there isn't a common standard for. That's why we have had in the past 5-6 years a lot of Sharia councils and a lot of Sharia organisations pop up, because they're trying to create the common standard. They're trying to unify a community that actually has a lot of issues with not having a set benchmark of what religious family mediation should be. And those Sharia councils are relatively new, but some of them are really quite, they're gender balanced, very representative, very transparent, consist of highly educated people who constantly write in the Times or in notable mainstream media rebutting the Islamophobic articles that you might often see. Articles that you may have come across recently with a Dutch scholar who's I would say recently published her findings, but actually her findings are 2 years old, but they sort of come back into the mainstream media because there's a bill going through Parliament, and Jasper is going to talk in a bit more detail about that, and that's the Arbitration Mediation Equality Bill. Now, this is a bill that was introduced, has gone through House of Lords, has gone through House of Commons. It's a private member's bill by Baroness Cox, which is why we might refer to it as the Baroness Cox bill. And it didn't get through, it wasn't approved the first time round, and now it's going through what you would say is a second ballot cherry. And so it's not just convenient, but it's quite open. Baroness Cox herself quite openly supports this Dutch scholar, and that's why you will find more and more controversial sort of statements and articles on her findings, because it's timely. It's timely because it brings into the mainstream a lot of the issues about whether or not British Muslim women who are using religious family mediation are having their human rights violated, or are they immediately subordinate in the process because of the fact that they're women. And so those are issues that we as a community need to deal with, and there's a lot that could be said about that. But if I just review, there are a lot of positives and then there are a lot of negatives in the use of religious family mediation. So within the context of Sharia councils, and I'm consciously trying to refer to them as Sharia councils because people often refer to them as Sharia courts, which they are not. They only have the authority and the jurisdiction, if you want to say that, to deal with religious issues or disputes that come up that people voluntarily want them to deal with. They don't have any legal jurisdiction. It's one that the community voluntarily surrenders to that Sharia council. And so by the very same note, it's it has a lot of benefits, because that panel or that mediator may have more of an influence with two people who might be having a breakdown of a relationship than, say, a judge. And I say that, and I don't say that lightly, because I'm a barrister, but the judiciary is not representative of our community and of the wider community in England. So therefore, there is going to be a gap between the community being able to receive a judicial outcome that is perhaps considerate of their ethnic, cultural, religious views, and one that they can then get from a judge that might not have that understanding, despite having experts and despite having a lot of academics and professionals that might be able to grid their views. There is a gap. So there is a benefit to having somebody there who might be a male or female Islamic scholar, because the people typically who volunteer to certain dispute resolution forms are more likely to abide by them, and that's just common sense. So therefore there'll be less likely need to litigate or to argue about the outcome afterwards, because these are processes they voluntarily subscribe to. Obviously it doesn't always work. You have these situations where people are so shocked by the outcome that actually they then decide that they're not going to agree to whatever they've maybe gone through the process of mediation. That happens everything, and that's why you always have the court there at hand if they need to access that later stage. So, people volunteer to it, therefore it's more binding, it's more flexible, it's more time-saving. I say that with a big bag of salt, because there are no standard processes for Islamic counsel, Sharia counsels, and the time length that they have for mediation. So they can be more time effective if they subscribe to a certain scheduled number of meetings, but more common than not, these mediation processes can take over years, over a year, easily, from the findings that we've found, that I've read, and from a lot of the academics who are doing research in this field. So you've got to caveat that. It depends which Sharia council you go to. And then there are a lot of positives in the sense that women will not be able to, and this is the key issue, they will not be able to get a religious divorce in an English court, because in more than half the cases that academics have researched into. So there was one study by Camilla who did, I think, around 40, she looked at 40 women, 40 religious marriages, and more than half of them hadn't had a civil registration. So that means more than half of those women cannot go to an English court for a divorce. So therefore, religious family mediation is then able to give an effective adjudication or an effective outcome to somebody who is unable to access any other venue in any other form to get to resolve this one issue. And it's a key issue, because then naturally it will then affect ability to remarry within that community, ability to claim maintenance, support, housing. It has such a knock-on effect. So mediation is able to deal with more issues than a court might be able to, and in this particular issue is able to. There are so many other benefits, those are sort of the key ones. There are then also negatives, and I've already brought them out just to sort of summarise them. The mediators themselves, you may have noted that I emphasise the fact that mediators should be trained and experienced. The mediators themselves typically aren't. More often than not, you have Islamic scholars, and Islamic scholars do not mediators make. They are just not trained. That doesn't necessarily mean that you are then, by the virtue of knowing and having knowledge about Islamic law, that you're then able to mediate, because mediation is a very unique individual skill. It requires training, it requires experience, it requires continued professional development. We don't have that standard within Sharia councils across England, and that's why we have such varied results and such varied processes. That's a massive negative that we have to take on board and we have to do something about. Of course, leading on to that, are then the Islamic scholars who emphasise reconciliation during mediation. This is a massive problem. People who go to a religious family mediation are going to that not because they're saying we want counselling, because counselling is a very different thing. They're going to religious family mediation, to Sharia councils, because they recognise the relationship has broken down. It's over. There is no possibility for reconciliation. They now need help to decide what their issues are and how to resolve them. The problem we have is, obviously, within Sharia, there is emphasis on trying to reconcile, but at what point the Islamic scholar comes into that process, we don't know, and the Islamic scholar obviously doesn't know, and so there is an assumption that they should therefore try reconciliation in a lot of Sharia councils, which should not be an assumption. And that's what leads to a lot of difficulties, particularly where women have to then, I say women, but there are men also who suffer from verbal or physical, emotional domestic violence. And so on both sides, you would have situations where, whereas the civil system would not even consider sending these parties to a first, meeting to discuss mediation, you have a situation where they're in mediation with potentially an Islamic scholar who's then trying to encourage them to reconcile over an indeterminate length of time because the process is so ill-defined. And that's what leads to a lot of the issues that we're hearing about now in mainstream media about whether or not there are human rights violations for British Muslim women who are subscribing to these processes. Whether they're exaggerated or whether they're real, my view, and I'll end on that, my view on that is that we don't have enough empirical data. We simply don't. I mean, I've just cited an academic study to you where it was around 30-40 marriages that were looked at. There are 3.2 million Muslims in England. It's completely absurd for us to begin to regulate Sharia councils when we don't even know how many there are, how they're operating. Are there actually standard processes for these places? Is it transparent? Is it actually gender equal? It could be, because some of these mediators might be local aunties, they might be Islamic scholars, they can be women, and they probably are, because in my experience, women tend to weigh in, especially in extended family, in these family issues more often than the male members of the extended family. So it's difficult to say that we should do this, or there should be recommendations where we should start to legislate, and we should start to regulate, and we should start to have criminalising, we should have sanctions or penalise certain particular members of society who don't subscribe to a certain standard. It's absurd because we, A, don't know what the problems are, and we, B, don't know if training and education would deal with a lot of those problems. So therefore, we're jumping to C, which is a disproportionate reaction, which might lead to, naturally, greater Islamophobia, more alienation of a Muslim society within England, and that would lead to more insular practices, even more people going behind closed doors to mediate and not reporting about it. So that, I end on that because I think that's one of the opening questions in the event summary. And I'll move it over to Jasper, who's going to talk a bit more about Baroness Bill Cox and mediation within the Sikh community.
Right, well, thank you for having me here this evening. My name is Jasper Singh. I'm a barrister in land building chambers. I've been in practice for the last 10 years. I'm also the chair of City Sikhs, which is a professional networking organisation for the Sikh community. Today I'm here in my capacity as a barrister, and I'm going to talk about the concept of alternate dispute resolution within a Sikh context. Within the Sikh community, there is no such thing as religious law. First and foremost, that needs to be clarified. There is perhaps cultural norms which are adhered to and which are perhaps encouraged within the Sikh community, but there is no law that Sikhs turn to when it comes to various issues as to disputes between individuals or any family matters, family difficulties. And it's important to stress that. The cultural aspect really comes from the Punjabi culture. And that, in my view, covers not just the Sikh community, but also in many respects the Hindu and obviously the Muslim community. Within Punjabi culture, there is a very strong identity and a strong nature that's felt from family members and also from the community at large. Now, the community at large could just be your local neighbours, it could be your local place of worship. It could extend further than that and include extended family from various parts of the country and also abroad. When there are difficulties, and again I'll stress this is more of a historic issue rather than something that is current in the present day. When there have been issues amongst Sikh families and there has been a breakdown between husband and wife and there are disputes emerging as to whether the two of them should remain married, whether they should divorce, what should happen with the children, what should happen with the finances that they've collected during the course of their marriage or prior to the marriage. It's been common for members of the Sikh community to turn to their immediate family initially, and then turn to community elders, people who are within the community who have been in a certain position of authority and who are able, in their view, to assist them with dealing with that particular circumstance. The efficacy of that is something completely different. Now, within Punjabi culture, and I'm assuming that many of you will be aware of this, there are the concepts of izzat and besti. That's important to remember here. The idea of remaining true to one's culture and one's cultural identity and preserving one's reputation within that community, as opposed to bringing shame upon the family and bringing shame upon the community as a large, besti. Those two aspects often come into conflict when there are these discussions about family breakdown. So you will have perhaps family members or extended family members or even other members from the community coming and talking to the couple who are undergoing difficulties and who will try to ensure that the couple can come to some sort of an agreement, that they can remain married, and that the fallout from the divorce or the breakdown of their relationship doesn't occur. The manner in which that is done can often be coercive. And you find that in many cases where you have community elders or external individuals who aren't qualified, first of all, who aren't mediators in an official sense, but are self-appointed individuals who are trying to assist, in their view, this particular family, you find that more often than not, they exacerbate the situation, they worsen it. You find that the couple themselves, as Shabana was saying earlier, may have reached a point where there is no opportunity for reconciliation, where they realise that the marriage or the relationship has come to a natural end. When you have community elders trying to impose their views in those circumstances, you find that it often causes other issues to crop up that one may never have imagined. And it can cause lots of difficulties within that context. Now, as I've said, I've been stressing that this is more of an historic assessment of how the Sikh community has dealt with such things internally in the past. And it comes from the context of a migrant community settling in the UK in the 50s or 60s, the idea of keeping the dirty linen that the community had private, and not really wanting to get involved in the processes, which for some were confusing, and secondly, were alien to many people who've settled here. There's a big generational gap, and you find that in the modern context, people who are perhaps under the age of 35, who are finding themselves in this situation, will consult their families, but would be more likely than not to just go through the legal route. They will see whether they can come to some sort of an agreement, whether they can do so in an amicable way, but if they find that the situation is such that they can't cope with being in that relationship anymore, they will just go down the legal route and use the court processes. There are two case studies that I can give, again looking at it from a Sikh background. The first is of a friend of mine, actually. She's a mother of two. She has been with her husband for about 10 years or so. Married when she was quite young, she's about 35, 36. She has had problems within her own family. Her husband has perpetrated domestic violence against her on a number of occasions. They did break up for a period of time. She separated, she moved back to her parents outside of London. Her parents then encouraged her to, for the sake of the children, go back and consider the reconciliation of this marriage. She did that. That lasted for about a year or two. That has now come to a complete end. The difficulty that she found herself in was due to not just her family members, but also the extended family on her husband's side, who effectively shamed her and coerced her into going back to her partner, her husband. She is now using the court processes to ensure that there is no repetition of that. She's now made her application for a divorce. She's sought a Non-Molestation Act, which is an injunction that one can get to prevent somebody from coming within a certain radius of your home, or to be intimidating, harassing or pestering you, or to even communicate with you. So she's seeking the legal route as being the way that she wants to resolve this particular situation. That's a unique case study, because as I've said, that's somebody who is, to some extent, in our peer group, in our generation. I'll now turn to somebody who, again, is an individual that I know of, who has been married to her husband for 39 years. She is perhaps more from the generation who was slightly unconvinced by the court system and how it operates. With her, she remained married despite the fact that she was a victim of domestic violence for almost the entirety of that marriage. It was only when she felt that her youngest child was old enough to be able to look after herself, she turned 18, that she felt confident enough to divorce her husband after 39 years. As you can imagine, it's a massive step for somebody for whom English is not her first language, who isn't eloquent, who isn't able to necessarily articulate herself even in her mother tongue of Punjabi, but it was a step that she felt was necessary to take. Prior to that, she had individuals within the local community telling her to just stay with her husband for the sake of it, because that's what people do. They have to just experience whatever happens to them and live with it for the sake of the children. That's all changing. And within the Sikh community, it's now, it's still a taboo to talk about divorce and to talk about family breakdowns, but it's no longer uncommon. And I think it's become acceptable within that context to go down the legal route and seek whatever redress one needs if one feels that the marriage is over, for whatever reason that may be. Now I'm going to turn to the bill, the Baroness Cox bill. It's quite short. I have it on my phone. It's only about 9 pages long, and this is the amended version that's going to be going to the House of Commons in the next few days. Within that, it looks at various amendments to other legal acts and other statutes. First of all, it's worth noting that it doesn't refer to any religion whatsoever. It refers to religions generally, but it doesn't specify that this is aimed at the Sharia councils or this is aimed at the Muslim faith or the Muslim community. Having said that, within the debate that's taken place in the House of Lords so far, and I'm sure in the debate that will take place in the House of Commons, it has been stressed that the reason why this is being created is because of the Sharia councils and because of concerns about the status of women within the Muslim community in Britain. And that becomes quite concerning. However, I would also say that those concerns are perhaps not as strong as one may otherwise have, given that this is a private member's bill. And the way that the Houses of Parliament operate is that private members' bills give an opportunity for a very specific issue to be debated and discussed. However, the likelihood of that actually becoming law is almost negligible. So that's something that should reassure people here as to what is likely to happen in the next few weeks. There's no support from the government for this private members' bill. What the government have said is that they want to have an independent review of the Sharia councils throughout the country, which is probably, in my view, a far more sensible idea given what we've heard from Shabana about how little we currently know about the number of Sharia councils, the quality of their work, and also the extent to which they deal with the various aspects that we've discussed on this between myself and Shabana now. Pros and cons. The pros of having mediation, be it in the cultural context or the religious context, is that first and foremost it saves money. It means you're not having to pay for legal bills, you're not having to pay for solicitors or barristers to attend court on your behalf or to fill out the various paperwork that needs to be done. And in this era of cutbacks, especially in respect of legal aid, that's something that is on the minds of many people when they go to when they start looking at whether or not they should proceed with any legal matters. How much is it going to cost? So it does save money. Secondly, it also enables the parties to come to an agreement themselves. But again, I would stress that's only in cases where it's clear there is no coercion, and secondly, where the parties, the husband and wife, are amicable. That's not the case in every divorce. And in the vast majority, where you do have attempts being made to have this sort of mediation taking place, where you may not have authorised or official mediators conducting this work, there is a risk of coercion. There's a fact that the scales of equality are tipped out of balance, and you find that the more vulnerable person between the two parties, and in many cases it can often be a number of people, given the trusts that were being discussed about properties, where you have a property which is purchased in not just one name, but it may be in 5 people's names and perhaps have 5 other people who have an interest within that property. But the more vulnerable people in any of those circumstances are the ones who are likely to suffer when you have that mediation taking place, simply because they don't have an advocate to speak on their behalf, to support them, and to ensure that the best outcome is being achieved on their behalf. It then comes down to a question of access to justice and also fairness. In my view, I believe that individuals should have the opportunity and the option of seeking this mediation. However, that should not be the end. It should be the first step, and if individuals aren't happy with that mediation and the outcome of that, they should then be allowed to go on to the court system and pursue matters in that way. That's all I have to say so far, and I look forward to hearing some of your questions.
Great, thank you, Jasmine. So, we'll open up the floor if there are any questions. If you're feeling a little shy, I jotted down a few questions to get things started. So, one question that I had for Siobhan, actually, you addressed to some extent, was how much we can separate religion from culture. I'm curious whether you've seen, from your research and what you've seen, do you get the same thing in the Muslim community? Would, for example, I don't know, somebody of Pakistani descent go in front of a Somali mediator? Would you never see that, for example?
It's a really good point, because actually a lot of the studies focus on Pakistani Muslims, and that's obviously a very specific demographic. But the trends that you find in terms of how mediation is, how the mediation had the process of it, the mediators used, the outcomes, whether they were effective outcomes or whether they were cause of equality, that all, there are a lot of factors that come into play when you assess that. Age is a bigger factor than many thought it might be. Then you also have the generation, is it a first generation, second or third generation ethnic minority? That affects things greatly. Maybe it wouldn't surprise you, but that's what studies have found, is actually the second, third generation, because of the rise of religious identity and social conservatism within Muslims, actually you find second and third generations are more willing to therefore subscribe to religious processes, whereas the first generation and the elders, and I prefer that, I refer to the immigrant community, they might be more amenable to subscribing to cultural norms as opposed to religious processes, but then perhaps mislabel that as religious. So there's a lot of complexity here, there are a lot of factors that come into play. It might not just be cultural and religious, there's also age, gender, which generation we're talking about, and also which community that we're talking about, socioeconomic background. I mean, there's so many different factors, but I mean, that's just generally what my experience has been. If I can add about the bill also, and I'm glad that Jasmine has highlighted it, put it into context, it's unlikely to actually come into, well, we hope that it's unlikely to actually come into an act. It's also the last bill of 40 that day, so it's actually unlikely to be heard on the 11th of March. But the reason why the concerns that underlie the bill may some might argue are valid. I would argue some of the concerns are valid. May not agree with how they've been dealt with, but one of the things that the bill does is it seeks to criminalise any scholars that might assert themselves as judges. That to me makes perfect sense in the context of a lot of the concerns that I've read and seen. So, I mean, that's just to add to what Jasmine said about the bill. But yeah, I hope that answers your question. Before I pass it over, actually, there's enough people here that I could ask this question to, but who here would use a mediator to resolve a family dispute? Can I have a show of hands? Because, I mean, I'm curious. That's interesting. There's only about 4 of you that would put your hand up.
A trained one.
A trained one, yeah. So if we had a sort of, this mythical accredited religious mediator who had a really robust approach to the schedule, and you had 2 people who were going to have equality and having their voices heard. So can I just have a proper show of hands? People sort of sheepishly put their hands up in the diagram. Okay, that's about 10% of you guys. It's good for me to know. Thank you.
Just to follow on from that question, actually, I'm curious, has anyone here actually had experience, either themselves or within their family, of going through a religious mediation process? So that's an interesting one to see, because there's no hands going up for that at all. One question I have for both of you is this process any more advanced in other countries? In the US, for example, or anywhere else in Europe, have we seen more progress when it comes to religious mediation? I don't know if either of you.
Yeah, I can answer that about the process in Scotland and Canada. So Canada's developed a lot faster than England has, and they have granted religious arbitration, which we don't have. So where you can have family arbitration here, it has to be based on English law. So people tend to get confused when you hear about Sharia courts and all of that. Actually, you can't have a family dispute being arbitrated and being legally binding in this country. It's just not allowed. Whereas you can in other countries. So I would say in that sense, we're further behind, and that has a knock-on effect on mediation, because what it means is that there's not enough impetus there for religious mediation to develop formally. If that was one part of an alternative dispute resolution structure, which then encompassed arbitration and that would be legally recognised, then you would find a lot more intellectuals going into the field, highly educated individuals, and you would find that people would then be a bit more worried and might pay a bit more heedance to having gender equality, age equality, and being representative. But because we don't have that, I think that does affect how quickly we are developing with mediation, and we're not. But also, I do think it's a little unfair, because so I want to caveat that answer. Whereas we may not have developed as quickly as we would like within Muslim mediation, we're also quite a young Muslim community in England. We haven't been here for very long. Our population is peaking at a faster rate than a lot of other countries. And then on top of that, we just happen to have a lot of other factors. So we just happen to have rise of religious identity. And that may not have been the case in other cultures and other religious communities. And then we also have, fundamentally, a global gaze on the Muslim community, which makes every development is microscopically analysed, and that also affects whether or not we're taking 1 step forward or 10 steps back. So I say that we haven't developed as quickly, but then that's because of a lot of other factors. So I think under the circumstances, actually, we are doing quite well in bringing these issues to the fore, and actually more and more people are less afraid to talk about the issues we have with particularly Muslim mediation. And you will hear a lot of Islamic scholars, the good ones anyway, criticising the issues that we have and proposing ways that we can bring that forward. But we just need more of it.
Jasmine, whether you had any other views on that?
I don't know, actually. I think Siobhan has covered it very well. I'm not too au fait with the development of religious arbitration in other countries. I am aware of the way that it operates to some extent within the UK, and one looks at perhaps the Beth Din within the Jewish community and the way that is more acceptable within many ways and within many people's eyes in the UK than Sharia is. One thing I would be very interested to see would be, regardless of the discussion that has happened within Parliament about the fact that this bill, if it were to succeed, would apply primarily to the Muslim community and to Sharia councils. I would be very interested to see what impact it has upon the Beth Din. The ecclesiastical courts in the UK existed up until about 100 years ago. We don't have them here. The Church of England doesn't have them. I think the Church of Scotland still has some, but they're very, very narrow in what they deal with, and they don't deal with family law, arbitration, or any matters of that ilk. But the Beth Din has been well established here for some time. So it would be interesting to see what impact it would have upon them if the bill were to go through. But as I've said, I think it's very unlikely that it ever will.
Thank you.
Subject to the findings of that independent inquiry.
Oh yes, no, of course. And I think that's what's more likely to happen, that it will be an independent inquiry to look into what the nature is of the Sharia Council and what can be done in order to regulate them. So if it's a question of regulation, that's something completely different. And I'm sure that's a topic for another day probably.
See, one thing I'm curious about is why does the bill make any reference to religion at all?
Well, it's under the context of, here we are. So it's in respect of discrimination between men and women. So it's gender discrimination. It's also in respect of, so if you bear with me,
It might help to give you some context. The bill came out of fears that Sharia women's evidence is, purportedly half of the value of a male giving evidence. And so that fed a lot of concerns into how much of an opportunity women were having in engaging with the process, how much their evidence was being weighted. Is that, that's a fundamental breach of a human right to a fair process. But also, then you had these situations which were becoming more and more reported in amongst the community and also mainstream media of women not getting religious divorces and suffering because of that within the community in all the ways that Jasper has explained. And that's why alongside several practitioners, Baroness Cox then proposed this bill, which is a private member's bill, so it's her bill, and so she's put it forward to the House of Lords to try and deal with those issues in what I would say an extremely disproportionate reaction and somewhat premature of a measure to take given the little that we do know. There is an independent inquiry and that's due to publish later this year, so it would make sense to at that point take stock and make reviews.
So, touching upon the religious aspect, it's dealing with primarily the discrimination of the provision of services under the Equality Act 2010, ensuring that men and women are treated equally in that respect. But more importantly, it's in respect of, as Shabana has just said, taking into, so it's steps involved in removing or minimising disadvantages suffered by persons who share a relevant protected characteristic that is connected to that characteristic, including steps to take account of the fact that those who are married only according to certain religious practices and not according to law, or are in a polygamous household, may be without legal protection. So what that does is it's trying to provide a legal framework for individuals who may have had the Nagar, may not have had a civil marriage, there may be 2 or 3 other co-wives within that marriage, and it's providing certain legal protection to them, which they would have under the jurisdiction of English law, but they would not have necessarily under the Sharia councils. So that's the context within which religion is used within the act, within the bill. But as I've said, it's just one very minor reference, although we all know what the purposes is for this particular bill.
Yeah.
Yes, Yusuf.
I'm very curious about this particular situation that you referred to, where the couple are not legal or English law married, but they are according to Islam. If the wife wants a divorce, but the husband refuses to recognise the Sharia court or council, what are her options? Can he just I refuse to engage in the process, and she's stuck, or has she got other things to record?
No, it depends which Sharia council you speak to. There is, you have a talaq, and you also have the khula. So a woman can pronounce a divorce And there are a lot of Sharia councils that are permitting women to go through established processes now. So, quite similar actually to how the court process is. So you serve notice on the other side and you give them time, and if they don't get back to you within a certain prescribed period of time, then you can progress to having the imam or the Islamic scholar then grant the divorce. But that's, it's varied. It depends on which council you go to. I don't know if anybody read in the news recently. I was talking to a colleague of mine, and somebody was saying that actually the woman isn't allowed to pronounce a divorce in Islamic law. It's only acceptable if the husband accepts her pronouncement of the divorce. So in that situation, if you went to a scholar like that who believed that, you would have a situation where she couldn't pronounce a divorce herself. She'd be even more limited in the options she has. So it really does depend on which school of, Islamic school of law you subscribe to, which Islamic scholar you use, what cultural background you have.
But following on from that, so if you then don't like the mediation, you can then go to another one and try again, and another one and try
Forum
again.
shopping is it's a real situation. Forum shopping happens with mediation as much as it happens with courts. People don't like an outcome, they'll go somewhere else. And that's just human nature view, people. That's why arbitration. Some people have pushed for arbitration because it would stop forum shopping, because you have a mediation process, but at the end of it, that agreement would be binding, or that arbitrator, or rather the mediator, the third person who's involved in that process, his decision or his involvement would be binding. But we don't have that here for family matters. So yes, that person could go to another mediation council.
I would just add that one of the reasons why we don't have it in the UK at the moment is the fact that there is it's about making sure that there is a parity between the individuals. That if the mediation, if the parties go to mediation, if they have an agreement, but if for any reason one of those parties thinks, well, actually, I was forced into agreeing this because the mediator or the other side, the husband or the wife, was being unnecessarily obtrusive or forcing me into a position where I couldn't say no. But in the light of day, actually, I'm not happy with the outcome. You can then go to the courts, and it's about ensuring that no authority apart from the English courts has supreme authority in any of these matters. That's the reason why we don't have it at the moment. It'll be interesting to see whether it actually develops as an area of law in the UK. At the moment, I think it unlikely, given that we haven't had a history of it here.
Yeah, we're miles away from it. One of my colleagues said that in family law, there are no votes to be won with family law reform, only votes to be lost. And the reason for that is because it's such a private issue. For politicians, it's just, there's no point venturing into such a controversial area for legal reform. If there were going to be legal reforms, it should probably start with what is marriage, civil registration. That's probably the fundamental issue. We still recognise Quakers and Jewish religious ceremonies, even though the Jewish community here is probably, in the last census, is around about 200,000, which completely, it's completely eclipsed by the Muslim community. So if we were going to start with legal reform, we would start there. But we're not going to, not anytime soon, because it's just too controversial an area and this isn't the political climate for it. Anybody else have any questions? No?
Okay, if anyone's got questions you want to ask individually, I assume both of you can stick around for a little while afterwards. So just a couple of points to add. So if any of you are new to the City Circle, we've got a sign-up sheet for our mailing list at the back so you can find out about future events. We also run a number of projects that you might be interested in getting involved in. So in particular, we have a project feeding the homeless, which runs on Sundays, and we also run 2 Saturday schools. You don't need any experience in teaching, but if you're interested in just learning a bit more, if you just put your name down on the sheet at the back, someone will get in touch and can talk you through what's involved.